Yeah, that was me.
This is
My dad used to be.
Thank you very much.
Put pineapple.
That's crazy.
So thanks again for
I
joining
don't,
us.
I mean, may no policies anymore.
All right. So thank you for joining us at the 9th Annual Startup Boston Week. Our mission with this conference is to bring the entire startup community together across every industry, department, stage of development, stage of funding. Startup Boston exists to connect, educate, and celebrate this ecosystem while serving as a trusted and unbiased guide to the best resources that can help you start and scale your startup. I'm Jeremy Brown. I'm a venture investor and advisor in the community, and I'm your room host today, I guess. Before we dive in, a huge thank you to Suffolk University for hosting us. Please encourage folks to check them out at the desk outside. They've got a ton of entrepreneurship programs, and there's opportunities for both people want to learn entrepreneurship as well as those that want to support the students. And I'd also like to say thank you to Touchstone for sponsoring this session and for sharing their wisdom with us for the next hour. So with that, I'll hand it over to Touchstone.
Hi, and welcome. Thank you, Jeremy. My name's Mike.
Elizabeth.
And we are the managing partners at Touchstone Strategic Law. We focus on helping startups, helping companies form, grow, and exit. And we thought it would be helpful to talk about the early stages of a venture and try to equip you with some vocabulary and a bit of a rubric for making empowered decisions as you're getting ready and launching a new venture, and then, or at the very least, feeling confident about having good questions to ask the people that you're seeking advice from. First, I would love to get a sense of where you guys are at in your journey. So, if we think about the light bulb, the idea, who here has their idea and is sort of still nurturing that idea but hasn't gone farther than that? Okay, and great. So we have some nascent ideas. Who here has the idea and now they're started to build it? Okay,
Fantastic.
awesome. And then of those of you who are building, have you started gathering a team? Okay. Wow, we got a nice spread here. Who has an office? Is that still a thing? No, apparently not in this small sample size. Has anybody started getting revenue, started growing? Okay, so we're pre-revenue. That's interesting. Oh, one in the back. All right. And take an investment, which could happen before or after actual revenue. Okay.
A couple.
Here's an interesting twist. Are any of you doing this while you're still at work? I got a person at work daydreaming here. That's this great graphic. Is anybody still at work at their 9 to 5 while working on the side project? Okay, interesting. So that presents some interesting twists that we'll talk about. So what we're going to do in this talk is focus on kind of the first half of that journey, that launching journey, with the goal of setting a venture up for that next part of the launch to go well. And
But it's not too late if you're past that first 90 days and you're listening to what we're saying and you're like, wait, I structured this. Maybe this isn't the right. These questions are still relevant and worth revisiting. It's not.
Absolutely, and no decision you make early on is irreparable, and neither are any of them perfect. There are trade-offs and unpredictable factors. So, many times we work with tech companies who have technical founders, and engineers come to us wanting to sort out, what the right way to go about forming their entity is and structuring it, and often there's a temptation to want to really engineer it perfectly, which, for those of you who are engineers, know kind of in the back of your mind that it's impossible. There are always trade-offs and unknowns. So thought we'd talk about incorporation first. And we can add a little background. I'm a general corporate counsel, you could say. So I advise on things like corporate structuring and contracts and anything that any legal aspect that comes into play in terms of operation of a company.
I, on the other hand, do all the super exciting stuff. Yeah, because I am the tax structuring person. I've done tax transactional and structuring work for about 20 years. And it is so much more fun than it sounds. But also, just to start off, I'll tell a quick story that happened right before I sent my daughter to school. Our paralegal, Mike, was going back and forth with our paralegal, who's in South America right now, about this. And he asked if it would be streamed. And I think Mike said that it was going to be live streamed on TikTok, which I found hilarious because I barely know what TikTok is. So I told my 16-year-old this morning, thinking she would immediately find it hilarious, but she was mortified. She said, Mom, no, like, this is not, no. So,
So
that's how
we
cool I am.
appreciate the audience being involved. That livens up our TikTok feed.
Any impromptu dancing is also welcome.
So when it comes to incorporation, thinking kind of big picture, I like to say that there are three factors involved. And the biggest one, in my opinion, by far, no offense to taxes, is fit for your business plan. And so, and this involves some prediction of the future, right? Business plans are painful in that respect, and that you're supposed to put in words what will happen in the future. And but the idea of a business plan is to kind of map out a journey that you hope to take over the next 3 to 5 years or so. And it's that journey that actually helps determine what kind of business entity is likely going to be the right fit for you. And so there's an interesting interplay between having your idea and thinking practically about how you're going to tackle it and ahead of forming a business entity. And as we go through, we can talk about more specifics of that. The next thing, I'd say the next most powerful factor is taxes. And the third, before we let Elizabeth talk about taxes for a bit, is administrative burden, which is lawyers, I think, often zoom past because it's all part of the biz for us. But for you as the entrepreneurs, each type of entity involves a different kind of number of layers of actually running it, even in those early stages when it's relatively thin. So it's something to think about in terms of how much paperwork different entities involve and whether that's a fit for you as a person dealing with that, or whether you don't want to have to deal with much of that. So maybe you can give a quick intro to some tax.
Yeah, no, absolutely. And when I say I do the tax planning and structuring, that isn't really as much to do with the forms you file at the end of the year. It's very related to the form you take for your business in the early days, in the first few years, or if you restructure down the road, which can impact the types of investors you take, what form those investments have. And it goes hand in hand with what type of business you're running. There are certain kinds of businesses that are very well suited for a very flexible LLC kind of approach, which we'll talk about. Other types might get some incredible economic advantages and tax advantages from having a corporate structure, especially when they're a smaller business stage. And by small business, I don't mean your early days, a couple of $100,000. The threshold for federal tax benefits for when I'm talking about the small business tax for the C corps, it would be like a $10 million threshold, or $50 million. You could get $10 million tax advantage, but that can be a business valued at $50 million. It's not small in my world necessarily, but small, I guess, in legislators' world. So different kinds of advantages and structures are appropriate for different kinds of businesses. And like Mike said, no decision is perfect, and they're not irreversible. There's some consequence. Some are more flexible to start out with. A lot of businesses start out as LLCs. That's pretty flexible. But while there may be more unwinding to do if you start out as a corporation and want to move to pass-through, it's always worth thinking about. It's a discussion worth having.
I think that as a non-tax person who resists being a tax person,
he definitely does.
The takeaway,
100% of the time.
The takeaway for me is that LLCs offer more flexibility for tax than corporations. And if you're a solo entrepreneur starting out, with employment income and trying to disturb your life as little as possible, often LLCs are a good starting point. So the other interesting question around a corporation is where, and we've all heard, Delaware is. I just realized that Delaware ends with where. Delaware is the where that we've all heard of most.
But somewhere you have Wyoming and Nevada,
Yes,
some others creeping in.
Yeah, and there are others competing for that space. And then often it's a choice between one of these business-friendly states and where you are, and then you can add to that aspects of your business plan, where you think you're going to grow, where you think your team might be, if you're actually going to have an office, where that might be. And all of that leads to kind of a big mashup of factors that to then make a pretty imperfect decision about where to be that, again, can change if it needs to.
Yeah. Although there's some, if you're thinking about maybe setting up a formal office in California or New York, just talk to us. It's better to think twice. You know, there's some states that are pretty aggressive. So.
Yeah, there are some states that will be more of a pain than others for sure. And then just again, the takeaway is that this is all these decisions you make on the fly as best you can with what you know at the time, and then it's okay to let them evolve. If when you sign a document, it feels so permanent, but there's more evolution that can take place than it seems. So the two most common types of entities for startups are definitely corporation and LLC. We're gonna, I think, focus a lot on the corporation because when we talk about these next interesting questions, because for two reasons, I think. The corporation has some structure that has some advantages, but that you have to live with, and it's also kind of known generally as the type of entity that investors may trend toward. It's not always the case. So we'll focus a lot on corporations and then add in kind of the counterpoint with the LLCs. And then, I want to mention that if any of you have questions or want to talk about some of these interesting other entities like nonprofits or benefit corporations, or even just being a sole proprietorship, it's something we can talk about after the session.
Also, LLC is the way we talk about it. A lot of these same considerations would apply to a limited liability partnership. That is much less common in the startup community, but if you say there are situations where I can imagine it coming up. Most notably, if you had an investor from Canada, say, or the UK, a jurisdiction that doesn't love the United States in their approach to limited liability companies and penalizes them in treaties. I can imagine, you don't want to go to a corporation. Maybe we talk about the equivalent of an LLC, but in the partnership context.
So you've created a corporation, and very quickly you have to think about how you're going to divide up ownership of the corporation.
Could I just break in to say that this pizza theme was not discussed or approved beforehand? So I don't know. This is really like him doing the pizza.
Apple pie felt played out,
I'm not sure I was on board with that.
I guess I wanted to say za. I don't know.
That gets worse.
So there's a couple of interesting questions. You create a corporation, and you get to kind of define how big your pizza is. Which is, you're ordering the size of pizza you want, and there's a couple of vocab words that I hope you can take away from this talk, which are authorized versus issued. So when you create a corporation, it's the currency of the corporation, the units of ownership are shares or stock. And when you create it, you get to define how many shares are authorized. And this is kind of like printing a bunch of money and then putting it in the treasury, in the basement of the treasury, where people wearing masks go to steal it. Is anybody seeing Money Heist? Which was the dumbest name change in the history of it. Casa de Papel was a way better name. Sorry, I digressed.
Yeah.
So you've authorized shares. They're in the treasury. Issuing them is putting them in circulation. And only the ones in circulation are what count towards thinking of how the size of the pie in terms of ownership. So your company may have a lot of shares in the treasury and just some portion issued to people, and it's just those issued portions that count towards 100% ownership. And so that can help you think about what you're doing, and there are some rules of thumb or sort of common practices that people use, and one is that the magic number tends to be 10 million shares, and the reason for that is it's a lot, and it's enough so that as you grow as a company and you're incentivizing more and more personnel with a small chunk of it, you don't have to get into fractional shares because that's annoying in Excel basically, and it's also enough so that you can issue a portion of it. It's usually around 20% at the beginning. And then as you bring in more people and bring in investors, you can issue more from those authorized shares that are out of circulation. You also get to define how much the pizza costs. That's called par value. You get to say what the par value of a share is. Usually it's some very small fraction of a penny. And again, you're trying to say my company is worth very little at the beginning, so that it has a lot of room to be worth a lot later, so that there's upside for you.
And this is really good for tax purposes as well, especially as a founder.
Right, because you're going to be issuing yourselves some shares, which are worth something, and could have, therefore, tax consequences. There are some states that have started to allow for no par value shares. I haven't seen that become the most popular way to go. What I have seen, I haven't seen everything, but what I have seen is that for both kind of accounting / finance purposes and for legal purposes, having some notional value is useful. Have you seen a lot of
I
no
haven't.
par people
I
jumping
think
on that?
no. I mean,
Yeah.
the difference is so tiny. It doesn't really move the needle, and I think that until it becomes a common practice, people will stay away. You know.
Yeah. We often start companies with a par value of 0.0001 of a penny worth for shares, which I don't even know how to say that number, but almost nothing. So then, thinking about dividing it up, I like to think about kind of 3 stages of the pizza party. So there's, just one second, but yeah, I'll get you. There's the founders, they get to eat first. And then you can think of there's kind of this in-between type of founder, which for purposes of our conversation, we'll call co-founders. The first 2 people starting right off are obviously co-founders, but there's kind of this next layer that isn't quite an early hire and comes on so early, but not right at the beginning. So we'll call them co-founders, but they often get kind of like a smaller slice than.
But
still
yeah.
big, but not like the first person.
And even a couple, I'm working with a early stage, but pretty successful startup in the coffee cafe space that isn't in Boston. Unfortunately, it's in New York and Texas, but they brought in an advisory board. And the advisory board definitely aren't founders, but they are getting an incentive kind of equity to help incentivize, their work and to have them be part, have ownership of the product and real stake. But they're not going to be employees in a traditional sense. So.
Yeah. And we'll talk in a second about those early team members and how to kind of put them in categories like that.
And that was an intentional move towards coffee, away from pizza. So we'll see.
We'll be moving on from pizza very quickly. And then there's kind of a long, very diverse set of early hiring stages. And so I often talk with founders about thinking about these stages of the pizza party and how to kind of think in terms of dividing up the ownership in orders of magnitude according to what their business plan looks like within those stages. We had a gentleman with a question.
Yeah. So the just a touch on the par value. So is that something? So you said 0.0001 of each share. Um, so is that an industry standard number? Is that something that the whoever is the company or the founder is coming to you with that number, or is that something that's provided by an organization or by the lawyer itself?
So ultimately, it's something that the founder or their lawyer provides to the state where they're forming their business entity. So they're saying, let's say I go to Delaware and I say, I want to start Mike Inc. and Mike Inc. is going to start with 10 million shares, and each share is going to be worth 0.0001 of a penny. And that's the par value. And so it's a number that I give to the state, and that gets formalized in my articles of incorporation, that document that's like my founding document of Mike Inc. And then, but it's sort of decided based a bit on the practicality of what, practicalities implicated of your business plan, and then kind of the practicalities of maintaining what's called your cap table, which is basically the spreadsheet that shows who owns what in your corporation, and then it is a bit of that is a common number because it is a practically advantageous number, but is not by any means the only number we see, and it's not a make or break decision.
It doesn't reflect obviously real value, economic value. I sometimes see 0.01 of a penny like that. But
the practical impact that I've seen this have is that you let's say you're a team of 3 and you're bringing on the 4th person, and that 4th person is like a kick-ass developer, and you can't pay them their market value, so you need to give them a bunch of equity, and often you give them we'll get to this, you give them stock options that have no tax implications for them, but sometimes they want shares, they want to be owners. And if you're going to give them, let's say, like a big chunk of the company, like 100,000 shares, 100,000 times times 100th of a penny, that's still, is that $1,000? Is 100 or $1,000? Accountants, please. So it's not an insignificant amount of money that you're giving them in the form of those shares, which therefore is going to have a tax impact on them, or they have to pay the company for those shares. So it becomes sort of this minor annoyance that gets in the way of what is otherwise supposed to be this really exciting transaction, where you're bringing on this person to get your company growing. And so if you start in the beginning with a lower value, this absurdly low value, then you avoid some of those things. I think the gentleman in the back is getting a microphone.
So to continue your analogy, I just want to know a little bit about the toppings, the anchovies, that sort of stuff. In the sense of what you were talking about in bringing on somebody. So I'm considering bringing on somebody who's an unproven entity. So I want to hold out the possibility to get something in the future, but I don't want to give him anything now until he's proven, and I want to know what's my escape route if, say, there's a 5-year vesting and it's just not working out, or he leaves or he dies or something like that. And can I do other things in terms of like warrants or options as opposed to giving the shares? Can I have a special class of shares in there?
Yeah, great
so
question. So we'll get to types of equity and thinking about those early hires in just a few minutes. I won't forget, okay? Sorry, go ahead.
Thank you. Yeah, just a quick question. You were talking about standards and how of the authorized shares, typically 20% are issued at the beginning. What stage are we talking? Like 20% divided between like the first co-founders, or does that take into consideration your stock option pool?
Yeah, great question. I mean, these aren't hard and fast numbers, but what I've often seen is 20% issued to the founders that are there on day one, and then and then a certain portion on top of that set aside for a personnel equity pool. At either right away if you want it there, or sort of when that moment is coming.
And some of this is intertwined and relates to what type of incentive equity you plan on offering. There are types and what structure you have. If you are working with an LLC, say you can issue something that I love, profits interests or incentive interests, and they have nothing to do with pizza toppings. Just as a side, but those are treated as issued equity. But you can have all the vesting conditions you want. They only can kick in when you reach a profit hurdle. For corporations, if you have a traditional option, that's not going to be issued on day one. The underlying equity is still hanging out there, not issued. But if you had something called like restricted stock, say you could have issued stock with restrictions on its performance and potential forfeiture conditions.
Yeah, we'll definitely get into that shortly. And so, speaking of toppings, just a quick nod to the LLC. LLCs come with almost no structure, and so thinking about ownership in LLC is a bit of a blank slate. You can get as crazy as putting pineapple on a pizza. I think I wish I were a slideshow designer.
Menu planner, designer.
So we've incorporated something. We're going to talk about sharing the power now that we talked about sharing the ownership. And you can think of this like you've just formed a little mini society. We're talking John Locke. You've taken something that didn't exist, you've created a name for it, and now it's time to create a governance structure for it. And at the very beginning, it is a monarchy for just a minute, basically. And does anybody happen to know the name of the person that is the equivalent to the monarch when you form a corporation? Maybe you've done it before and have a guess. No? Okay.
Chairman.
That's the second layer. There's this interesting first layer that disappears very quickly called the sole incorporator. So the person that files the form, that signs the form and files the form to create the corporation, for a minute, they own and are in charge of everything.
For a second, I was the sole incorporator when I was a paralegal before law school of
Right.
a lot of companies. It didn't bring me far, but.
Right. And then usually that power is quickly handed off to what we will call the Constitutional Congress. This is a group of people. Does anybody have a guess? Board, exactly. So the board kind of starts as the first legitimate rulers of the corporation, and they then appoint the executive branch. So you guys were talking about president, secretary, CEO. That's the executive branch.
Mm-hmm.
And then who are the voters in this little society? Shareholders, exactly. So you, as you're thinking about starting your company and these roles, these are the kinds of powers that you're dividing. The analogy to a democracy is fairly strong.
And not all of the voters, not all of the shareholders are necessarily created equal. You can have different classes, different voting rights, different economic preferences, really, and that should reflect your business, if you have investors coming on, your investors' needs and how negotiations go.
So our little mini society will also have the equivalence of a constitution. Does anybody have a guess about what that is? The name of that? What'd you say? Articles of incorporation, sometimes also called certificate of incorporation, depending on what state you're in, and then also the bylaws. With that together form the governing document. And then there's actually an equivalent to legislation. Remember the Congress, the board. How does a board make a decision? Has anybody been through this before? So the board has to vote on something called resolutions or consents. A bunch of resolutions form a consent often. And these are decisions that are then handed down to the executive branch of the company to implement. Now, at the beginning, there's this weird stage where you, as the founder, or your co-founders, are all of these things. You are wearing all the hats. So you are the king, or the monarch, rather. You guys should definitely boo when I make that kind of gender mistake. Thank you. I need it. We need to provide feedback. And then, so you're the monarch, you're the Congress, the executive, and maybe the sole voter, which is sort of a confusing position to be in at first. And you kind of have to step to the side, put on your different hat to do one thing, step back, put on the other hat, and you quickly get used to those formalities, and it can become fast and easy for making early decisions. Somebody there in the almond shirt, did you have a question? Did I wait so long that you forgot it?
I'll just make a comment that you could have put cat in the hat in that picture.
Also true. Yeah.
Slide notes for you.
Okay,
But I do
yeah.
forget my questions, so I'll ask you later.
So sorry about that. So sorry. So this looks like an incomplete slide, but it's actually meant to sort of drive home the point again that sharing power in LLC is very much a blank slate. It is very flexible, and for that reason is often a good fit for an early business, because there's very little formality in terms of making decisions. And then you can build it up into something highly structured, similar to a corporation. We've seen LLC, their foundational document is the operating agreement. We've seen and worked on LLC operating agreements that basically turn something that for tax purposes is an LLC into something that is governed exactly like a corporation.
And that can be driven by lots of factors. But to go back to my client that has cafes, they want to be an LLC until an investor might persuade them to do otherwise. But they're taking on, they've taken on a lot of crowdfunding investment, and they're taking on a $5 million private equity investor that wants terms. They want rights, they want more formality. So we're bulking up their LLC agreement, building in some oversight and class rights to make that work. And the LLC is flexible enough to get you there.
So now we'll get to this interesting question of early team members and how to think about them, and then how to incentivize them with equity. So I find it's helpful to think about these things with two lenses, one a business lens and one a legal lens. And then you kind of bring the two together when you need to take some sort of legal action. So from a business standpoint, I find that there are some categories to think about. Like there are full-time team members, part-time team members, and notice I'm saying team members, I'm not saying employees, because that's a legal definition. So we're thinking about like how long they spend, how much effort they put into your company. Advisors, usually they're like a few times a month, maybe at most. And then there's consultants who have kind of a specific subject matter that you're leaning on them about, but that are not, it's a mushy line between a consultant and an advisor, but sometimes it's easier to know, based on a specific situation. And then from a legal standpoint, we have these sort of annoying terms: W-2 employee, 1099 contractor, and business owner. And these have different legal implications for what the person's role is. And if you think about a matrix of these categories, it's not completely flexible, but there is a lot of ability to kind of choose what legal formality to place on a particular person and their role in the company. And so often when working with entrepreneurs, I think we find that they come to us wanting to propose a specific legal solution, and it's often helpful to back up and think about the business purpose behind a role, and then apply a particular legal solution based on what's optimal. And so I encourage you with this and with any of these things, with your lawyer, come to your lawyer with a business goal, as opposed to asking for a specific legal solution, and that lawyer can provide the best legal
Our
solution.
role, lawyer's role in general, should be to help you implement your business goals and plans in the best way possible. It shouldn't be to have, even from the awesome world of tax, I shouldn't drive the bus in terms of how your company looks. It really should be responsive and tailored towards the needs and realities of your day-to-day business.
Was there a question back there?
Hi, I set up two LLCs, two different businesses unrelated to each other. And in a legal standpoint, I would like to understand, am I doing the right thing, or is there some sort of legal ramifications, or should I bundle the two businesses within the corporation? And then on the tax side, do I have any tax advantage by combining them? Again, they're totally unrelated.
Yeah, so my answer is going to be completely unsatisfying, which is that it depends. And so we can chat a bit outside, but that's it's an interesting question where it depends a lot on whether you have these two ideas that you intend to ramp up separately, and then perhaps and that people are going to maybe want to invest in separately. And then that you may want to have acquired separately, whether these are indeed two distinct business plans, or if the business is really you, the person, and that you have these endeavors that are providing you revenue and satisfaction, and then perhaps having one thing makes more sense. I don't want you to take away an answer from that very short delve into the question. But so it's kind of it's a matter of kind of teasing apart what your motivations are and what your plans
And
are.
what you think from a 2 to 5 year perspective, what that looks like. The good news is that with LLCs, if you're the sole owner, you're in a good place. You haven't made any mistakes, or right now there's lots of options to either put them with one holding LLC if you wanted to combine, or to keep them separate and maybe even more formally segregate them. But you won't have, right now there's no liability contagion.
So getting to the question from a few minutes ago about equity for team, and so here's some concepts that you can think through, and we can weigh in on the ways that people try to kind of hedge their bets and make sure they're not incentivizing people too early or too much. So you can think of this in two categories. There are other types of equity, but these are the two most common, and they provide a helpful divide. So a share or stock is an actual piece of ownership of the company, whereas an option is the ability to purchase that share later. And so one is you own something now, one is you have a right to buy it later.
Mm-hmm. And this doesn't translate perfectly into the LLC world. You can have an option for an LLC, but people do it. It's taking something that's meant to fit a C Corp, putting it in an LLC. It doesn't fit great. It doesn't have the most advantages. LLC world, you'll often hear about profits interest or incentive interests, and that can do a lot of the same things.
So there are now, within the category of shares or stock, there are two different ways to think about this as well, and this is mostly for tax purposes, but and can get very. It's one of these classic legal fictions where with shares or stock, they're most often issued in the form of restricted stock, which means there are restrictions placed on what the recipient can do. They can't just transfer it out on the open market to other people. There are often vesting restrictions, meaning they don't really have full control over the shares they've been given until they meet certain requirements of length of service to the company. Sometimes there are performance-related vesting restrictions, so achieving certain performance metrics, so that's trickier. And then there has become something more recently called the restricted stock unit, which is an agreement that instead of you being given the shares and then over time vesting restrictions being lifted, it is an agreement that you are given the shares after certain time benchmarks or performance benchmarks that could be are met. So you can think of the difference between these two things as restricted stock units or RSUs being something on layaway. You bought the TV, but it's kept at the store. The restricted stock, you take the TV home, but it won't turn on. There's like there's a device that won't let it turn on or you can't get all the channels until you've hit certain benchmarks that allow you to fully own the TV. For all intents and purposes, it's kind of the same to you, except for tax purposes.
Yes, there are definitely tax and planning considerations for both of those. That can tend to be, one can be better from the employee side versus the company side. That can get pretty technical. I want to also throw out another incentive concept that you may have come across, which is like a phantom equity, a phantom share. And this is if you wanted to give somebody, usually this is for more rank and file employees, not a founder level, but you wanted to give them a incentive comp without giving them real equity. And it's almost like a bonus that mimics the share performance. So they're not getting real equity, but it can feel like the employer, the recipient, is invested in the company because their bonus, their incentives will mirror what happens with the performance of the underlying stock.
That's like you don't get the TV at all, but you get the price of selling the TV when the company gets around to selling the TV.
This metaphor.
Yeah.
This went too far.
So, options, and again, this is a distinction that is largely almost entirely for tax purposes, but there are the word you'll hear often is incentive stock options or ISOs, and these are for your W-2 employees. These are people that work for you in that traditional legal sense, and they come with tax benefits, lower tax consequences should the options be exercised and sold. And then there's something called non-statutory stock options, NSOs, and these are for anybody other than W-2 employees. So you can give somebody the benefit of an option, the tax benefit of not receiving something of value right away because it's just an opportunity to get shares later. But they don't quite have the same tax benefits later. The difference kind of being between NSOs in a certain sense are treated as income. So like when you pay your income taxes, you pay like 30% on. So NSOs, if you profit from them, it's treated as income more or less. ISOs are treated as capital gains. It's like about half. Mm-hmm. And so employees get that benefit.
Yeah, and this is another concept that doesn't translate into the LLC or partnership world. Again, there's lots of tax efficient, great ways of getting benefits to these incentive comp or executive comp, but you don't throw terms like incentive stock options or non-qualified just don't match up.
So to address your question in the back about a new unproven team member, any of these different types of equity might apply. And vesting can be placed on any of them. I find that options tend to be a better fit for somebody you're skeptical about, that you're not trying to get married to, basically. Because for a couple different reasons. One, a shareholder has rights. They have voting rights on certain fundamental things, and they have informational rights. An option holder does not, because they don't actually own the shares yet. The other thing is that options they always come with expiration periods. So if they're not exercised after a certain amount of time, either from issuance or after the person is fired, or leaves the company for any other reason. But if we're thinking about this worst case scenario, like the new hire doesn't pan out, you're forced to get rid of them because you don't want to pay them anymore. Now maybe they vested some equity, so they're going to walk away with some options. Those options can expire such that those options are then pulled back into the company treasury. So options are often a better option for relationships that you're unsure about.
In an LLC context, there's also lots of ways of doing this. The profits interests that I've been mentioning, those really you can get as creative as you want. They're always going to be tied to the underlying profit or value of the company. But it also, if you wanted instead, say you had a couple of different LLCs in the same structure, and this employee was only going to be working or really responsible for one of them, you can say this profits interest will start participating after X number of years, and if the profitability of this subsidiary hits X dollars, that's when you start getting whatever rights you agree to give them. So there's many ways, I think, of incentivizing your service providers while at the same time protecting yourself.
But options have to be exercised at a price, which requires an outlay of money from this employee down the road, which she may not have at that point in time. Whereas if you give them something now, then there's no outlay of money down the road.
So I've found that that's often unpredictable, which the recipient might prefer. Like it depends on how risk averse or enthusiastic they are about the upside. So some would prefer not to have to receive anything of value right away. Some like the options because it's non-committal. Often when options are exercised, it's at the point of an exit. So you are buying the shares in that moment at a much lower price than they're being sold for, but they're being bought and sold basically in the same transaction. And so, like if your company is getting acquired, then and I owned 100 options in your company at and the strike price of the options was $1, I would never have to hand you that $100. I would just get $100 off the sale price of the shares that I would be buying with them, if that makes sense.
You have a short-term tax gain, which would be trust with the long-term tax.
I mean, I want to cover kind of a few more concepts before we run out, but again, I mean, and Elizabeth maybe afterwards can talk more with you, but I just find that you never know what they are going to prefer, or you know.
And it like some of that will depend on the difference between incentive stock, the qualified options, non-qualified options, and there's also tensions between you have day one taxes versus taxes when you exercise or when you ultimately sell. You're definitely right that there are pluses and minuses. If you were an employee, you would definitely have views, depending on your tax situation and profile.
And one other, I guess, point is that quite often, I mean, it's essential when it comes to issuing options in a corporation, the company has to have what's called an equity plan. And so to the extent you can set up that equity plan and then present to your early hires, look, this is our plan, this is what we have available, this is what works for our company, then that narrows the conversation somewhat. There are still these early conversations with key people that you really want to incentivize, or lure to join you, that where maybe they're going to negotiate and have strong enough interests that they'll force you to sort of step outside the boxes you've created, but you can try to create those boxes early to simplify your life and kind of discourage a lot of broader thinking. So let's talk real quick about a couple key concepts when it comes to IP. So you have this idea that you're nurturing. How do you protect it? And there's some different concepts to tease apart. So when it comes to the idea, of value that you're going to be offering your clients or your customers. There's two interesting concepts to start thinking about: the patent and the trade secret. And basically, these are in some ways opposites. So with a patent, you are protecting something by declaring to the world that you made it first. But you have to tell the world how you made it. With a trade secret, you're protecting it by keeping all that on lockdown. And those two things can have different pluses or minuses depending upon your business situation. So investors often want to see a patent pending that can provide some reassurance or some curb appeal. But patents cost a lot to, what they call it, prosecute. And so there's a big investment that you're making over a period of probably years. Trade secrets don't involve that costly process, but it is more challenging to keep everything on lockdown as your organization grows. And so there's trade-offs to work on. Now, when it comes to the concepts trademark and copyright, these are brand protection and content protection mechanisms. So trademark is about your logo, your slogan, things that characterize and your product or service and that help your audience know them. Copyright applies to any original content. It's often just things you create that describe your business, or sometimes there are content-based businesses where copyright actually protects the thing of value. So now we can run through real quick some of these issues that pop up if you're still at your 9-to-5 and thinking about if and when to launch. I cannot emphasize how important this is. It's one I don't like to practice law, like fear-based law, but this is the one thing where it might actually feel justified to me to be a little anxious about. If you're still at your 9-to-5 and want to start working on your venture, figure out what kind of assignment of IP you have made to your employer, and figure out and then dig into how to safely set aside this new thing that you want to develop and launch. Otherwise, it can lead to entanglements. Sometimes your employer doesn't care, isn't paying attention, and it's never an issue. But when it is an issue, it's really painful and challenging. When to incorporate? Do you do it while you're still at your 9-to-5 and developing your idea? Do you do it when you're ready to launch? This is often a question of again, it goes back to your personal business plan and how it fits in. But it's something to start, putting into your business plan when you want to create that business entity. The issue of naming can be really complex, and I encourage you to start thinking about it early because, I've been there myself. You have a great idea. It's really fun to think about the name. You wake up with the perfect name. It's really exciting. You can get ahead of yourself if you start stamping that name on your idea without first thinking about, is that domain name available? Are there any similar trademarks? Are there any similar products out there? And then thinking practically, this is outside the scope of legal practice, but I always have to encourage founders to think about it when they're thinking about the legal aspects of naming, but thinking about, does your name actually describe your product to your customers? And if not, is that fine with you? Does it help with SEO? All these other to the extent your name will be this anchor for your brand, thinking about it ahead of time is often really disappointing because you've come up with this amazing analogy that means a lot to you personally, and but may not have the practical value you wish for.
Like za pizza.
Right.
Yeah.
Yeah. Whoever came up with za. Yeah.
Yeah.
And then
All comes full circle.
And then the issue of building these early business relationships, My strong opinion is to go slowly, date for a long time before getting married, and to your business partner, and then don't get married to your business partner. Because just like a personal relationship, you're going to be working really closely with a person, and aspects of your dynamic will unfold slowly. And so to the extent you're still at your 9 to 5 and nurturing an idea, then it's awesome to have these collaborations, meeting for coffee, thinking about things, but think about how to, using NDAs and clear communication, think about how to slowly develop those business partnerships before you dive in with something.
I promise it's really worth it to set out when it's very easy to get caught up and excited about working with somebody that shares the same passions and vision, and you're feeding off each other and having a lot of great ideas, but coming up with the ground rules, the economic splits, just going through those discussions is worth it, because it'll make the process as you grow, even in best case scenario, you grow, you're amazingly successful, you have an acquisition, you're going to need to know, like you're going to have different economic interest, like you're not going to be fully aligned on all matters at all times.
So it has some awesome slides analogizing zombies to lawyers and vice
He
versa.
did. He's done this for.
But we ran out of time. So
The zombies.
this is us. We do some free office hours if you want to talk about things in more depth. At our website, we have some blog posts about these same topics to go into more depth. And so
I have
we're
some
happy to
business cards
chit-chat.
over there that it would be awesome if you would grab them, because I really want to buy new business cards, but I can't justify it because I never use them. So if you take those, then that'll be great. It'll be the
Thank you.
Oh, huge thank you to Touchstone. All right, still a lot more ahead for the day. We have a slightly longer break here. This room will restart again at 1 with Plugged In. Also, just for those that aren't aware, we do have the startup crawl happening tonight, kicking off at 6:30. Spots are limited, so be on time downstairs at 6:30 to make sure that you're registered. And with that, I guess lastly, please get your picture taken, connect with Kevin Tai from 3 Circle Studio and his team, grab a photo, and if you kind of scan one of these or come by and scan the one I'm holding in my hand or give me your phone number, you'll get a photo book. It'll use face recognition and give you all the photos for you from the event. So with that, really appreciate everybody's time, and hope to see you at the next one.
Thanks, Jeremy.
Thanks, everyone.